Be agreed to. I call the Honourable Member Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, I want to begin my remarks today by acknowledging the new Minister of Justice, the Honourable Judith Collins, and to wish her well in her justice portfolio. I also want to recognise the consultative approach that she has adopted early on in her stewardship of the portfolio. And I think it's appropriate to acknowledge also that she has a Herculean task ahead of her in trying to rationalise the workload that she has inherited. It is, as I have said previously in this House, a difficult workload to have inherited. It's a grab bag of measures, frankly, some of which sit half or not even half completed. And I think that it will be important for her with respect to rationalise the workload that she has inherited. And in doing that, I've already expressed to her privately that the Labour opposition will offer its support to the sensible measures that are part of that legacy, although not all of those measures, because I'm not sure, frankly, that history will be kind to her predecessor in the portfolio. Mr Power was a popular member of this House and a charming member of this House, but frankly the backlog that now sits in the justice portfolio waiting to be processed is most undesirable. And frankly also the record reflects that Mr Power wasn't willing, frankly, to consult on measures that he ought to have consulted on, particularly on this one, where it is undoubtedly desirable that there be a multi-party consensus on the powers of search and surveillance that the state ought to be able to exercise. So this legislation has a protracted history. Labour introduced the original Search and Surveillance Powers Bill back in 2008, following a Law Commission report. The bill, as the Minister has said, was extensively modified via select committee process, in which the Labour team was led by my predecessor as Shadow Attorney-General, the Honourable David Parker. And I want to also pay tribute to Mr Parker for the diligence that he showed in that exercise. As the Select Committee report from November 2010 shows, his work contributed to a much better bill that emerged from the committee rather than what entered it. And in singling out Mr Parker for praise, I want to join the Minister in congratulating the other members of the Select Committee on the work that they did. It is clear that this is a much better bill. There are significant modifications to the proposed surveillance device regime, better regulation of the more intrusive forms of surveillance that were originally proposed, a reduction in the warrantless surveillance period, better rules over the retention of data, stronger reporting requirements for surveillance device warrants, better controls over examination and production orders. And so it is absolutely the case that Parliament did what it is expected to do via the Select Committee process on this measure. It did look at the detail, the parties worked together, and they did produce a better bill. But, Sir, Labour left the Select Committee process with three issues that it remained concerned and dissatisfied about. And as soon as that process ended back in November 2010, Mr Parker wrote to Mr Power and he said, "These are the three issues that we need you to address in order to get multi-party, that is Labour support, as well as national support for the legislation. First of all, there needs to be an exemption for the news media for production and examination orders. The powers relating to the Serious Fraud Office concerning production and examination orders ought to be brought into line with the powers that are going to be conferred on the police by this bill. And the thresholds for the availability of production and examination orders in respect of the offences that they would apply to should be raised generally from 7 to 10 years. So those were the three issues. And these are important issues, sir, particularly in the time that we sit now of declining media freedoms and concerns For example, as had been raised earlier in question time by my colleague Claire Curran about apparent political influence at New Zealand On Air, concerns around turning Television New Zealand through less than transparent means into a commercial broadcaster rather than a public broadcaster, a state broadcaster with those characteristics, the resourcing of Radio New Zealand and the adequacy of that, concerns about deals done with private broadcasters like Media Works involving a senior minister, and of course the tea tapes. Now, all these matters are matters of concern relating to the climate of media freedom in this country. And they are matters that we cannot ignore. They are matters that are directly within the purview of this bill, and they're matters that really have to be dealt with if we are going to make progress here. Now, consideration of the bill became more urgent last year because of the Hamed decision already referred to by the Minister. The legislation had been languishing on the order paper for a year when the Supreme Court decision forced Parliament to act late last year in those dying days of the last Parliament, when we put in place an interim regime which is due to expire next month. So clearly we are in a tight time frame to deal with this problem, but it took Mr Power a full year to give Mr Parker a substantive reply to the three concerns that he raised, not received, as Mr Parker says, until after the election, and essentially he put the burden on Mrs Collins to deal with these three concerns. Now, the Minister and I met yesterday. She wrote to me today, and I accept her good faith attempt to try to resolve these problems. And as in passing, I should say that I appreciate, in respect of at least two other measures that I can think of, the approach that she's already showed in this portfolio. She's willing to stand back, take a look at whether a measure is really necessary, whether or not it really commands stakeholder support, and if it's not, she's willing to give it another look, and that is something that ought to be said for the record. The problem we have with this legislation is, as I've said, we are in an urgent legislative phase here because of the expiry of the interim bill, the interim act, next month. We still don't have a supplementary order paper, even though I acknowledge the Minister's commitment to share it when it is ready, but as the Leader of the House signalled before question time, we could be 5 days away from the committee stages. And so we have the problem really over the issue of media freedoms, and that is this. Even though the Minister says she will ensure that it's a High Court warrant that will be required for a production or examination order against the media rather than a District Court warrant, and that's a great step forward, there's still the problem that the police have the material in their possession in the interim while the order is being applied for and while objections are being processed. And the journalists and their sources are going to know that. They're going to know that the enforcement authorities of the state can see that material before a judge can pronounce on its admissibility, because a copy can be kept to prevent its destruction. And until we can get that fundamental issue dealt with, as I've said to the Minister, we do have a real issue. I think on the other two matters that are outstanding, the Minister's given an undertaking about reporting on the serious fraud office powers, which I know she's consulted her colleague about, and we'll give that careful consideration. On the issue of the 7 or 10 years issue, well, I'm not sure that that's so much of a problem. We could have a schedule of offences in the bill. We'd know what was in and what was out, and that would get around the objection that's been raised. So, Sir, if this measure proceeds past a second reading, I hope a satisfactory supplementary order paper can be produced and considered in time, and that if it is, we can support the measure. But, Sir, meanwhile, without a supplementary order paper to consider, with the committee stages maybe 5 days away, and without the objections that Labor has consistently raised now for over a year, it isn't possible for us to support the legislation in its current form, and we will be voting against the second reading of this bill.
I call the honourable member Tim McIndoe.